Okay, so if you've been anywhere near the news lately, you know the name Jeffrey Epstein is back, big time. And the fallout, well, it just keeps going, often in really high stakes ways. Today, we're doing a deep dive into one specific legal fight. It's a really significant one that's now heading towards the U.S. Supreme Court. We're talking about Ghislaine Maxwell's appeal.
That's right. And right at the heart of it, the absolute core, is this fascinating, really contentious legal question. Basically, did that non-prosecution deal federal prosecutors made with Epstein way back in 2007 in Florida, should that have actually protected her from the charges she later faced in New York?
Sounds technical, I know, but believe me, the implications are huge.
Oh, definitely.
So, our mission today, we want to cut through all the noise surrounding this. We're going to unpack the legal arguments, the really complex ones. We'll explore why this case matters so much, beyond just the headlines, and try to understand all the different perspectives. The goal is to give you a really clear picture of what's actually going on. All right, so to really get why the Supreme Court appeal is such a big deal, let's just remind ourselves where Ghislaine Maxwell stands right now. She is currently serving a 20-year prison sentence. That came after a New York jury found her guilty back in 2021. The conviction was for helping Epstein sexually abuse teenage girls.
Right. So her main argument now, the core of her appeal, is that the conviction itself is invalid. And it's all because of that 2007 non-prosecution agreement, the NPA, made with Epstein down in Florida. Her lawyers are arguing the deal also, quote, shielded his associates. And the key bit of language they're pointing to is this phrase in the agreement. It says, let me get it right. The United States also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein.
Wow. Okay, so an old Florida agreement potentially wiping out a New York conviction from years later. That sounds pretty major. What makes this specific argument so potent, especially when you're talking about getting the Supreme Court's attention?
Well, it's interesting because this isn't just some obscure loophole they found. It taps into what's called an unsettled matter of U.S. law.
Hmm.
Think about it like this. The federal court system has these different regions, right?
Mhm.
Circuit courts. And they haven't all agreed on how to interpret this kind of situation.
Different courts, different rules.
Kind of, yeah.
Yep.
On this specific point, Mitchell Epner, he's a former federal prosecutor, he put it pretty well. He said, the question of whether a plea agreement from one U.S. attorney's office binds other federal prosecution as a whole is a serious issue that has split the circuits.
Yeah.
And that circuit split, that fundamental disagreement between different parts of the federal judiciary, that's exactly the kind of thing the Supreme Court looks for when deciding whether to take a case. It signals, the law needs clarifying from the top.
Okay, so the lower courts are divided. How is the government, the Justice Department, reacting to Maxwell trying to take this all the way up to the Supreme Court?
Well, interestingly, the Justice Department, this was under the Trump administration, when they filed their brief, they acknowledged the circuit split exists, but they still urged the Supreme Court not to take the case. The Solicitor General, D. John Sauer, he's the government's top lawyer, before the Supreme Court basically argued that the differences between courts are, quote, of limited importance. His point was that the scope of a plea or similar agreement is under the control of the parties to the agreement, essentially. That was Epstein's deal. He signed it. It doesn't automatically cover Maxwell.
Right. So what are Maxwell's lawyers firing back with? They must have a strong counter to that.
Oh, absolutely. Her attorneys, David Oscar Marcus and Mona Marcus, they filed a pretty forceful reply just recently. Their core point is she simply shouldn't have been prosecuted, period, even though her name isn't in the NPA. And they basically say, look, whether or not this was wise, it was the deal, and petitioner is entitled to enforce it.
So a deal's a deal, essentially.
That's the line. And they push back hard on the government's interpretation. They argue the NPA wasn't limited geographically just to Florida. They also say it wasn't conditional on the government knowing who the co-conspirators were back in 2007. And critically, they state, it does not depend on what any particular government attorney may have had in his or her head about who might be a co-conspirator, and it contains no other caveat or exception. They're trying to frame it much bigger, saying this isn't just about Ghislaine Maxwell. It's about whether the government is held to its word.
That point about the government keeping its word, that feels like it has broader implications, doesn't it? Is anyone else weighing in on that legal principle here?
It really does resonate. And yes, the National Association of Criminal Defense Lawyers, the NACDL, they've also filed a brief urging the Supreme Court to take the case. They point out just how common plea agreements are. They resolve the vast majority of criminal cases. And they stress how vital it is for the government to actually stick to the deals it makes. Their argument ties into Maxwell's. The lack of any geographical limit in the Epstein NPA means, in their view, that no part of the DOJ anywhere in the country should have brought charges against any co-conspirator. It's about consistency and trust in the system.
Okay, this is where it starts to get even more tangled, right? Because this very specific, very technical legal argument is playing out against this backdrop of, well, a huge public uproar over files relating to Jeffrey Epstein. And then there was that recent meeting, wasn't there, between Deputy Attorney General Todd Blanche, who used to be Trump's personal lawyer, and Maxwell in Florida. Her lawyer called it a very productive day. How do the Epstein files connect to this appeal?
Right. It's impossible to ignore the context. And yes, the appeal absolutely touches on the whole controversy surrounding the Epstein files. You might remember the FBI has been withholding a lot of documents from their Epstein investigation. There was a Freedom of Information Act lawsuit, Radar Online versus the FBI. The FBI cited something called Exemption 7A. That's a legal reason they can use to keep records secret if releasing them could reasonably be expected to interfere with enforcement proceedings.
Okay, so they argued releasing the files would mess up an ongoing case. What did the court decide about that? And crucially, how does that tie back to Maxwell's appeal potentially going to the Supreme Court?
Exactly. The court actually agreed with the FBI at the time. It specifically said that releasing the files could reasonably be expected to interfere with the pending prosecution of the defendant in a pending related case, and that pending case, it was identified as a potential retrial of Ghislaine Maxwell. So here's the potential link. If the Supreme Court ultimately rejects Maxwell's appeal, that specific justification the DOJ used protecting a potential Maxwell retrial it might just disappear.
So the legal shield for keeping those files secret could vanish if the appeal fails.
Precisely. The DOJ might lose that well-documented rationale they've been using.
You know, given everything surrounding Epstein and Maxwell, the public interest here is just off the charts. There's so much speculation online, so many strong opinions. And just to be clear, for everyone listening, we're going to touch on some of these reactions, just to understand the public mood, okay? We're not endorsing anything, just reporting on the discourse out there. What are you seeing?
It's intense. What's really striking isn't just the volume, but the deep mistrust of the system that seems to run through a lot of it. You see a lot of talk, for example, about the timing of this appeal, especially with recent comments or actions linked to the Trump administration. And that feeds into worries. You see this online about the Supreme Court maybe being influenced, or even concerns that the justices could be labeled, pedophile supporters if they rule in Maxwell's favor. It gets very heated.
Yeah, you can feel the emotion behind a lot of those comments.
Definitely. And of course, the Epstein case itself has always been a magnet for conspiracy theories about him, his death, his powerful connections. Those haven't gone away. Some people are speculating quite openly that maybe this appeal is like a backdoor pardon, a way to get her out without a formal presidential pardon, or even theories that maybe she could trade information, names perhaps, that could be used against political figures. It runs the gamut.
Right.
And then there are more sort of legally minded discussions, too. Some people are drawing parallels to debates about nationwide injunctions, wondering if that same logic about limiting federal power in one area might apply here, making the NPA binding everywhere. But underlying it all, there's this palpable anger and, frankly, fear among segments of the public about whether the justice system can actually deliver accountability in a case this big, this sensitive.
And adding fuel to that fire, I suppose, are President Trump's own recent comments about potentially pardoning Maxwell. That threw another log on the fire, didn't it?
It absolutely did. He was asked about it directly. His response was, well, I'm allowed to give her a pardon, but nobody's approached me with it. Nobody's asked me about it. He also said right now it would be inappropriate to talk about it, but then repeated, I'm allowed to do it, but it's something I have not thought about. And of course, everyone remembers that the current Supreme Court has a 6-3 conservative majority, and 3 of those justices were appointed by Trump himself. That connection isn't lost on people.
So you have this perfect storm, a complex legal issue dividing courts, huge public anger and suspicion, and this political overlay. What does this mean for the Supreme Court justices themselves? This must be a tough call, even just deciding whether to hear the case.
It's a huge challenge. Look, the Supreme Court is incredibly selective. They get thousands of appeals every year, maybe over 4,000, and they only hear about, 70? They have very broad discretion to pick and choose. And you need at least 4 of the 9 justices to agree just to take a case, to grant certiorari. Professor Daniel Richman at Columbia Law, he pointed out something interesting. He said it was actually pretty unusual for the prosecutors in Florida back in '07 to include that protection for unnamed co-conspirators in Epstein's deal in the first place. Because of those unique facts, he suggests maybe this isn't the cleanest case. Maybe it's a poor vehicle for the court to use to resolve that bigger circuit split issue. Its specific details are just too weird.
So it might be too messy, legally speaking.
Potentially. And Richmond also explicitly said he hoped political fallout wouldn't sway the justice's decision on whether to take the case or not, which tells you something about the pressure they're likely feeling.
Right. So for all of us watching this, what's the timeline? When might we know if the Supreme Court is actually going to hear Maxwell's appeal?
The justices usually consider these petitions, these requests to hear cases, during their conference in late September before the new term officially starts. So we should get an idea then. If they do decide to grant the appeal, then arguments would likely happen sometime during the new court term, which starts in October. And a final ruling in that scenario probably wouldn't come until sometime before the end of next June. Remember, she's already lost appeals at the trial court level, the district court, and then at the Second Circuit Court of Appeals in New York. So the Supreme Court appeal is really the next logical step and potentially the last one in the federal system for her.
Wow. Okay, so we've really peeled back the layers here, haven't we? We've gone from the nitty-gritty legal details of this non-prosecution agreement and the split it's causing in the courts, all the way to the intense public reaction, the swirling politics, the whole issue of the Epstein files. It's incredibly complex.
It really is. You've got this core tension, right? On one hand, the legal world is grappling with a genuine important question about how federal plea deals work across different districts.
Yeah.
That's a real issue. But on the other hand, you have this overwhelming public demand for justice, for transparency, especially in a case as disturbing and high profile as this one. It's legal principle versus public trust, in a way.
Which leaves us all with a pretty heavy thought to chew on, doesn't it? When you look at all these legal complexities tangled up with such intense public interest and distrust, what does this whole situation really tell us about the state of our justice system, about its perceived fairness, its integrity, and how did these massive headline-grabbing cases ultimately challenge how we think about accountability, not just for the people involved, but for the system itself? Definitely something to keep thinking about as this case moves forward.